Yes, sir. Please go ahead. We are live now.
One and all. And on behalf of ASSOCHAM's National Council of Insolvency and Bankruptcy Code and Valuation, we take pleasure and pride to invite one and all panelists, our chief guests, as well as all the attendees into this National E-Summit series. Just to give you a precursor, this is the third out of the fourth E-Summit, which has been organized by ASSOCHAM's Insolvency and Bankruptcy Code and Valuation. And we have with us our knowledge partners, CRISIL, also, who have been very supportive to us in this series of National E-Summit series. This couldn't have been more timely and the topic couldn't have been more apt, wherein today we speak about the resolution plans and the commercial wisdom of the COC and the Indian valuation system. The recent report by the Finance Committee chaired by Shri Jayant Sinha has been recently come out, wherein they have in depth spoken about the IBC's pitfalls as well as its solutions, and keeping into mind the timely resolutions and the value maximization objective of the code. This detailed report has been made available, I'm sure, and we will have an opportunity to discuss in detail the report as well as its findings. But just to run you through the key findings is that this committee has spoken at length about the various stakeholders and the key constituents which will make sure and ensure the timely resolution and value maximization objective of the code. COC and the commercial wisdom of the COC has been spoken at length and breadth in this report, as well as at various forums and quorums. We also in our previous series have been speaking about this, which has been one of the key reasons for also the delay which has been seen, primarily because of the NCLT being clogged up with a lot of issues pertaining to the commercial wisdoms. There have been decisions taken by the COCs which have been challenged at the NCLT and NCLT level. NCLTs have given their opinion into the commercial wisdoms and the decisions taken by the COCs. The COC have not been empowered enough. There is no standardizations of rules and procedures for the COC and the members representing the banks and the COCs, which have all in all, probably delayed the entire process of the timely resolutions. However, there are also key recommendations for the way forward, and which is what we would like to also discuss in detail today, giving a overall holistic view of what has happened in the past, what is happening currently, and which is the way forward, which is very exciting to see. So few key things which came out of that report was, one was the flexibility in the resolution plans. At this point in time, we don't have a flexibility to break down the businesses of a corporate debtor at the CIRP stage and probably sell that. So if you have different flowers in a bouquet and if you sell them differently instead of selling the entire bouquet as a whole, the marketability and probably the value maximization might be a very, very different ballgame altogether. So this is one clear thing which has come out from the report. Along with that, in the liquidation rules 32E, which talks about the CD as a going concern. So that has been challenged, as well as that has been proposed and suggested to be deleted. And in line of the corporate debtor as a going concern, the businesses of a corporate debtor as a going concern has been asked to be elaborated at length and breadth, and probably that is the clear message that the various businesses may be bifurcated and sold separately, both in the CIRP as well as CLP stage. Along with this, there are also discussions on the digitization of the entire IBC ecosystem and pre-packs, the way it has already been panned out for the MSMEs. The CD in possession and creditor in control is a great combination. It has been discussed at length if this can be further incorporated for the corporates as well, and not just limited to the extent of the MSMEs. Home buyers and strengthening their rights, and we've seen how the code has been amended since there has been a lot of stress in the real estate sector, and how the code has been quickly and dynamically amended to protect the rights of the home buyers. So these were the few of the key points which has been discussed at the committee and has already been put forth to both the houses. Apart from this, there are a few other points being discussed which we shall be discussing in detail today, also few of which have been cross-border insolvency, primarily because there are a lot of companies having assets and interests all over the globe, and hence the cross-border insolvency becomes imperative. Same is the case with the group insolvency. Because of the holding company structure or the SPV structure, there are so many companies which have interlinked assets and businesses, and the marketability being very different in an individual company or a group insolvency basis, and hence the need for the evolution of the group insolvency. And needless to say, the national ARC, NARCL, also called the bad bank, and how it is going to pan out, the accounts being transferred there. So these are the various points which we are living in at this point in time. And without much ado, I will take this opportunity to first and foremost introduce our illustrious panel. We have with us Shri Ritesh Kavadia ji, who is an executive director at the Insolvency and Bankruptcy Board of India, IBBI, being the regulator of the insolvency professionals, as well as the valuers in the entire ecosystem. We have with us Shri Gauri Panda. Gauri is an associate director at CRISIL, CRISIL being our knowledge partners in this entire e-summit series. We have with us Mahima Singh, who is a managing associate at Chandiok and Mahajan Advocates and Solicitors. We have with us Ankit Goyal, who is a registered valuer and partner at AAA Valuation Professionals LLP, who are a registered valuer entity. We also have with us Kiran Chonkar, who is a partner and handles the M&A at BDO India. Ankur Srivastav is a registered insolvency professional, as well as the managing partner at EZY Laws. We have Jyoti Singh, who is a founder and at the AJA Legal and Associates. And last but not the least, we have Deepak Mani, who is the vice president at the Insolvency Professional Advocate. So I would like to welcome all the panelists today at this point in time, and looking forward to a great, wonderful session. And I also take an opportunity again to welcome all the attendees. We have with us Gauri Panda, who has prepared an illustrious presentation for this session. And I would like to hand over to Gauri to take it forward to run us through your illustrious presentation by CRISIL, who are our knowledge partners for this e-series. Gauri.
Am I audible?
Yes, now you're audible, Gauri.
Yeah. Thank you, Saljit. So I'll just run past the presentation currently. So my screen is visible, right?
Yes, it is visible, Gauri. Please go ahead.
Okay. So thanks very much for considering us as a knowledge partner. So before we start, I would like to give a brief background how this stressed asset space has been shaping up in India for the last 5 to 7 years. Apart from the changes in IBC, what we have been seeing also the RBI guideline to for the restructuring and reorganization of stressed assets in India. There's an increased participation of stressed asset funds, especially the global funds and the domestic funds also in India, and the evolution of asset reconstruction companies, and last but not the least, the national ARC, who is the new player. Obviously, there has been a significant change what we have been seeing in the stressed asset space, and in that context, what we are seeing is a lot of activity in the stressed asset industry as such, and there has been changes in IBC. And when we are talking about stressed asset opportunities, we have to talk about the trends in NPAs, because ultimately that will give a kind of background on what are the opportunities currently. What we are seeing is that around GNPAs to cross around 10 lakh crore by March 2020. So 1 year earlier, what we were the major portion, around top 50, 60 accounts were contributing around 40% of NPAs. Now, if you see the majority is coming from what we are expecting, it is coming from MSMEs and retail segments, which are expected to be more vulnerable than large corporates. And NBFCs, obviously, they have their own NPA issues also. They are estimated at around 1.5 lakh crore. Overall, these stressed asset opportunities, what we are seeing, I think it should be originating from this as a whole. Now coming to in overall resolution mechanism, what we are seeing, there are various mechanisms in place. However, IVC has been playing a very stellar role, and it's a WhatsApp mechanism in our financial ecosystem. I'll just touch upon 2-3 slides on that, how the ecosystem has been developing for the faster resolution of stressed assets. And we have been seeing there is rapid admission of cases. There are around, the change in creditor in position to debtor in position to creditor in position, where operational creditors are also filing the cases. And there are a number of insolvency professionals and resolution registered valuers. They are day by day they are increasing. Now, this is the breakup of cases what as of March 2021, and here we can see there's a clear-cut, the breakup where we see the approval of resolutions till the liquidation. Our, let's take a pause over here and just think through the what kind of process is this? It's very complicated. There are too much of intricacies involved in the whole resolution process. And in this resolution process, the most important aspects we need to look at is that the function of resolution professionals, the function of committee of creditors, and the kind of resolution plans which are coming to picture, and simultaneously or the parallelly what the importance of valuation, because valuation that gives you a benchmark for the resolution of the COC to decide whether to go ahead for that resolution plan or not. That's the kind of benchmark we usually see. Now, in this context, today, what as Sahil also highlighted, the theme would be the Indian valuation system, what we are going to briefly talk about, and the panelists also they will deliberate on that. And apart from that, the role of committee of creditors, the commercial wisdom part of that. And finally, we are going to kind of discuss upon how the timeliness of recovery or the resolution would make a difference in overall CIRP system. Now, starting with why the valuation is very critical. Obviously, the true price which we are trying to discover is in a normal market economy where automatically nobody is going to discover a price. There is some organization, some person or some profession where he is going to decide the estimated price of a particular asset in different simulated context. Obviously, now that process of estimation, what we all know, that is the valuation, and that is very important when that profession is when we are talking about, because he is going to play a very critical role, and that valuation report or whatever he is going to provide, that has to be very authentic, because that is a critical input for evaluation of the resolution plans and going forward the decision making process in the CIRP. Now, from the Indian valuation system point of view, that we know that there is a significant demand for valuation services in India and across various statutes like your services, securities tax, banking, and insolvency. And there are registered valuers under you. IBC, you have SEBI regulations, you have Companies Act, and there are proposals for RBs to be a part of MR regulation as well. However, one more important point to highlight is that there's a draft valuer bill which has been proposed, which will be taken to the Parliament House, where the main objective is for the regulation and development of valuation professions and to protect user interest in this progress. And that is the most important aspect, where a primary regulatory body will be has been designed, which is called National Institute of Valuers, under whom your valuer professional organizations, institutes, and other valuers to be registered and to be kind of regulated. How the ecosystem for the valuation has been developing under IBC, which we are very much aware. It has been every year on year the significant development what we are seeing. We have seen around 4,300 individual RVs and around 40 RV entities, and there are 16 RVOs. Now, this is a significant increase when we see it in total 4,300 RVs. And these registration of valuation under IB every year, that kind of augurs well for the total valuation, overall valuation ecosystem. Now, as we are aware, the valuation under IBC at different mechanisms it is required, whether it is CIRP or PIRP, whether it is a normal liquidation or voluntary liquidation or a fast track CIRP. Under various scenarios, the valuation is required, and obviously for the CIRP you need two RVs, to determine the fair value and liquidation value. And third valuer is required if there is a significant deviation from two valuation reports. Now, this is the broad understanding of what is required, what is not required, and we all know, and we are going to deliberate on the nuances of that. However, the most important aspect what we would like to highlight is that what are the challenges usually they face, the valuers face, or in the CIRP process, in a normal valuation process, or when the end user uses the valuation reports, how are the thing, what are the challenges broadly they face from the valuer point of view and from the end user point of view. Now, key challenges what we have just jotted down here is that the different from the end user point of view, maybe the different valuation methods. Probably that gives a kind of puts the end user in a confusing state of mind whether to, because if there is a significant variation in two valuation reports and different methodologies are used, then it's not going to give a proper feedback to the end user. Obviously, undervaluation and the overvaluation also makes a difference, and that kind of leads to a significant change in resolution plans as well. Similarly, lack of documentation and limited or no access to your information. This is from the valuer point of view. That creates a significant impact or a lot of hurdle for them to go ahead and do justice to their role and to give a proper value. How we are going to see the way forward for this overall Indian valuation system, and what are the things we need to see as in whole, where the recent valuer draft proposal, draft bill, which has been proposed, and the NIV, the National Institute of Valuer, which is proposed under that bill, that is the overall process. It's a very structurally positive step, which will strengthen the overall valuation system per se. However, every new system needs to be tested first, and secondly, the timely implementation also. That is the most important aspect. And second, most important aspect is the creation of a standard valuation framework or a valuation system, because most of the RVs, especially under IVBA, they follow international valuation standards. We should have our own Indian valuation standards. Obviously, ICAI, they have the standards. Now, this would standardized valuation would help in avoiding overlapping any job of valuer across statutories. That is something is going to give a very good support. And whatever we are going to develop, that should be also internationally accepted. Further, the institutes which will be registered under the normal process, and in general also, where they are going to compete with each other, they have to have quality education, to provide quality education to the end users or the valuers who are going to get themselves registered. And there has to be a standard valuation report format across categories, across asset classes. Maybe we can categorize the asset classes across statutes, and there has to be standardized valuation format, and everybody has to follow that. So, having discussed the broad aspects of the valuation system and perspective of from IBC point of view, and what are the challenges and the way forward, let me move to the next theme, that is, as I have highlighted in my earlier slides, that the most important aspect of the resolution process, that is resolution plan, and the commercial wisdom of committee of creditors, because they are the key people who are going to decide whether the plan needs to be taken ahead or needs to be rejected at that point in time. Now, everybody knows that the intention of a resolution plan obviously is to rescue, right? And it's not only rescue and to recover, but to maximize the value of the underlying asset. That is the very critical aspect. We are not here. IBC is not for the purpose of recovery. It is for the maximization. That is the twin objective: timeliness and the resolution timeliness, and maximization of underlying value. So, how much critical the role of COC? So broadly, we have just put together, how centrally it is located, how it is critically linked to all the stakeholders in the resolution process. Now, what we believe is the supreme decision maker, being the supreme decision maker, they determine the viability of the overall business and they examine the feasibility of the future operation. So it is completely up to their prerogative or the understanding or their decision making to go ahead with whether to take up the resolution plan or to not go ahead with the resolution plan. Now there it comes the commercial wisdom, which plays a very key role, and that is the important aspect of COC, which always has been discussed in the various forums. And when we talk about commercial wisdom, the apex court, the Supreme Court of India, they have also upheld through their various judgments the primacy of COC and their commercial wisdom. What they have clearly clarified that whatever decision they are taking, it shouldn't be interfered by any adjudicating authority like NCLT or NCLAT. A few examples like we have highlighted where case Sasidaran versus Indian Overseas Bank, or the landmark case of ArcelorMittal, the SR Steel case. So what we just wanted to highlight is that, okay, the primacy and the commercial wisdom of COC is upheld, but there are few key responsibilities which the COC should or the must balance, and they have the duties towards all the stakeholders in a fair, equitable manner. They have to treat everybody to take the resolution process forward, and the quickly and timely decision making ability of COC also makes a significant difference, and where they have to manage the internal conflicts of interest and take the overall process forward. As the financial committee report by Mr. Jain Sinha, they have highlighted, there has to be a code of conduct for COCs as well, which is maybe very much required at this point in time to streamline the overall process. So in total, in a kind of IBC report card, we have seen obviously the financial discipline and resolution that is on track, what we have seen till now. Timeliness of resolution, your judicial infrastructure, that has also been highlighted in the finance committee report by Mr. Johnson, the NCLT infrastructure, which needs to be strengthened. And role of COC, obviously, we believe that it is in process, but it is in place, but it has to be strengthened further. Similarly, one of the key aspects what we would like to highlight is secondary market for stressed assets, which is very important from overall supply to address the supply and demand gap of the assets in the stressed asset from the Indian context. And what we have to learn from the recent the processes what has been executed through for the Videocon resolution, where the cross-border of the group is insolvency mechanism, for that the code has to be implemented as soon as possible. So in total, what are the drivers for the improvement of maybe the resolution timelines and the recovery per se? The strengthening of code and the associated ecosystem, that is very critical. Although IBBI and Government of India, they have been addressing the issues, but it is very much important at this point in time. Similarly, you need to be the closure of vintage assets has to be taken off in a time-bound manner and quickly. And the reference to IBC also, there has to be addressed very quickly. Further, MSME, the prepex for MSME, which has been recently introduced. Now, it has to be expanded beyond corporates. Why we are saying beyond corporates? Because obviously for MSME, it has to be tested first. It is very critical. It has to be tested, and once that is successful, it can be taken up for corporates as well. And digitalization of IBC platform, which is very critical. That will going to be the critical. That is the theme for our next event, the fourth event in the series. And last but not the least, the marketability of these stressed assets, because when you develop this secondary market and you have the information repository to access the information for the investors, then only you can have a very viable and vibrant secondary market where you can address the issue of the stressed asset in India. With that, I think I'd like to conclude my presentation, and I would like to hand it over to Sahil to take the process forward for an enriching panel discussion. Thanks. Thank you.
Thank you so much, Gauri, for a very detailed and illustrious presentation covering the agenda and the key discussion points of the current summit. And we thank you again for this. Now moving forward, we understand that we have various key stakeholders who are part of this entire IBC process and the entire ecosystem. And value maximization is something that we have been hearing time and again. And who better than a valuer can talk about the various current nuances of the current Indian valuation systems and the way forward. Gauri touched base upon the points of the draft valuer bill currently, which is under process. Along with that, we have two parallel systems running at this point in time. One is the registered valuer under the Wealth Tax Act. So that at the time of giving a loan, a bank empanels a valuer, and the valuer under the Wealth Tax Act carries out the valuation. However, at the time of an insolvency, the valuer registered under the IBBI has to be empaneled and has to carry out the valuation, and not the valuer empaneled by the bank. So there are two different regimes, two different panels per se, which are running in parallel, and different bodies who are regulating the entire valuers. Hence, there is little or low standardization in the valuation reports, and we have only limited valuation standards in India, and hence we are looking at the other international valuation standards. So all these are the key points that we look at from the valuations perspective, and let's hear it in detail from Ankit to take us through this entire valuation ecosystem. Ankit, over to you.
Thanks, Sahil, and thanks, Gauri, for introducing everyone to the nitty-gritties of the valuation system and what are we looking at in future. So there has been, I would say, a lot of development, a lot of reforms already that have happened in the valuation system. If we go back before 2017, when this present system under which valuations are being done under IBC was put in place, we were looking at a system where valuers were simply getting recognized by the income tax department through a provision in the Wealth Tax Act, which was created in 1960s for the purpose of empaneling valuers will be helping the department in understanding the values of various assets so that the wealth tax department can impose tax and accept the wealth tax levied on those valuations. And that was the system that was adopted because that was perhaps the only system which recognized valuers for a long, long time in India. Unfortunately, that system does not have a framework for education. Once you become a registered valuer under the Wealth Tax Act, there is no provision which requires you to pass an examination. There is nothing that tests you for your knowledge. You have qualified for a particular number of years as a chartered accountant or as a chartered engineer, architect. You can apply to the income tax department, maybe follow up 3 4 times and get yourself a wealth tax registration number which lasts you for eternity. So it is not something with that kind of rewards a continuous exposure or a increase in knowledge and valuation. Number two, I would say that this system under Companies Act, which was brought in 2017, it has been growing as we see that yes, the number of registered valuers across all asset classes, that is land and building, plant and machinery, and securities of financial assets has been growing since 2017 when the first registration started happening, 2018 rather. And also what we are seeing is more and more registered valuer entities getting registered, and many of these 40 or 43 registered valuer entities are entities for all three asset classes. So what you're seeing here is something which is a merger happening. So earlier there was a stark demarcation. Oh, this is a land and building valuer. Maybe he will get work from the banks and from those clients who want a valuation done. So what are the valuations required? One can ask, okay, give me a 20,000 one valuation for income tax capital gain. Maybe you can give something for income tax act purposes. So and that's a very limited scope. But today we are saying that yes, in our own firm and even other entities which we appoint as valuers from our insolvency entity, we see that all the asset valuers are working together, working on common assumptions, working to give a report which should not be easily be challenged by the by any contester, by the promoters, representatives, by other people. on some ground that no, this is something that doesn't even capture the basic assumptions that should be assumed in this kind of evaluation. Importance of valuation is something that we all have always understood. Evaluations are important right from day one when a bank uses that valuation report to mortgage an asset and give out a loan. At that point in time, if the bank is told by the valuer that this asset is priced at 200 rupees and the actual price is 50 rupees, that's a big threat on the future honor of the or future repayment of the loan. Because if you start with that kind of a margin, there is always an incentive for the promoter to just ditch the bank and let the bank try and recover whatever can be recovered. So security, wherever this bank is seeking security, is of course important when all the provisioning requirements under IBI and under RBI regulations also require the provisioning in a different manner for secured assets and a different manner for unsecured assets. So therefore, this part is also important. And there in this field, it is not even important for one to have a wealth tax registration. If somebody has been working with banks for a long time, they can continue as valuers. Now, what has happened in the draft valuer bill is that they have tried to incorporate and bring in everyone through a transition mechanism. So, starting from the idea that the new proposed act looks into covering Banking Regulation Act, Securities Contracts Act, Wealth Tax, Income Tax, SEBI, IRDA, PEMA, SURFACI, PMLA, LLP Act, Companies Act, the Pension Funds Regulatory and Development Authority, the Black Money Act, the IBC, and then it also says that the scope will extend to non-regulatory valuations. So it covers everything in the house. Then it says that the sole regulator will be NIV, and it says that anything that anyone has against any valuer where they have not followed a standard, where they have not met the requirements, the complaints can be raised against NIV with NIV, and the NIV will take action, very similar to the structure that is already with IBBI. But what happens in case a bank gets a valuation done from a valuer who is not a registered valuer today? There is no regulatory provision for any action which can be taken against that valuer other than barring the valuer from that bank. But the problem is that valuer will continue working for other banks. He will only be barred from that specific bank. So there has to be regulatory teeth, so that the valuers can serve the clients. And I continue saying that if the valuers are not able to meet the purpose of the valuation for which the client is giving them the job, then they should rather not do a valuation at all. Some things that I feel require change beyond all this is we see that there is continuous threat on the independence of the valuer at various forums, and that is something that I will like to bring out at this forum. I of course will not be naming any banks or institutions, but we have seen with private banks, public banks, that there is no formal system of appointing the valuer. If there is no formal system of appointing the valuer, the independence of the valuer goes for a toss, because the team with which the valuer is working can then say that your fee or remittance of your fee is reliant on the value that you are giving with respect to this property. In fact, in many cases, what we have seen is that the fee is received only for those cases which end up being sanctioned, and the fee is not given for those cases where the loan is not disbursed. Now imagine the plight of the valuer, that in case he genuinely feels that this valuation or this property is worth only 25 lakhs, he will have to give a higher valuation just so that the disbursement happens and his fee is received. So this is a serious threat to independence, where this kind of a barrier or this kind of a system is utterly, I would say, illogical, that is being practiced currently in the banks. And this needs to change. The second thing is confidentiality. So there has been a recent case in the Videocon matter where the confidentiality of the valuation report has also been talked about, and that needs lots of emphasis, lots of rather I would say declarations that yes, at any point in time the confidentiality of the valuation report should be preserved. Without that, there can be serious threat to the IBC process. Leave alone the IBC process, even otherwise also in other regulations also there can be a serious threat on the independence of the valuation. The intention of sharing a draft valuation report or the idea behind that has always been that since valuation requires a lot of information from the client, and when you share the draft valuable, when you share the draft valuation report, when you share the assumptions that a valuer has taken, there is an opportunity for the client to share more information, and that more information can then be added into your valuation report, or your assumptions can be corrected to give out the final report. But what is actually happening is that the draft valuer bill becomes a ground for discussion. That is the valuation right. वो इसको थोड़ा सा बढ़ा दो, उसको थोड़ा सा कम कर दो. That is never the intention of a draft valuer bill. So there has to be a formal system through which the draft valuation reports can be shared with the client, maybe a platform that has been designed by the regulator, so that the changes which are made over and above the draft valuation report should always be changes that are required to be made because of some required corrections, because of some additional information, additional documents. And this is where I believe this requires some focus so that the independence is preserved and independence is taken forward. And apart from that, there has been a lot of development in using caveats, limitations, and disclaimers. We have seen various NCLTs, courts, and CLADs thrashing away valuation reports because of the acute nature of caveats, limitations, and disclosures that have been stated by valuers. Fortunately, there has been an attempt to control those in the sense that there has been a circular called Guidelines on caveats, limitations, and disclaimers and use thereof in valuation reports by IBBI, which is also having a mandatory requirement to be followed. And that not only, fortunately, does not only cover CLDs, caveats, limitations, and disclaimers, it also covers various other requirements that are supposed to be in the valuation reports that perhaps were already covered as part of the international valuation standards, but are now part of this. Another thing I would like to add before I end my talk is that we need valuation standards. We need customized Indian valuation standards or some kind of guidance on what customizations are required for what purposes of valuation. So today I have what? I have an international valuation standard which I'm supposed to follow because I'm a member of IOV RVF, and there they have adopted these standards, and therefore as an organization triple evaluation is required to follow those standards. But when I do a valuation for a bank, when I do a valuation which is not required under statute, I am I can choose to follow those standards, I can choose not to follow those standards, number one. Number two, I then have a conflict where I have to adopt to the regulatory requirement or to the requirement of the banks in the formats that they want me to fill the valuation report in. And that convergence is something that becomes difficult to be done at times, because in case the bank tells you that the valuation report has to be a 3-page report, there is a fixed format in which the bank wants you to fill in that valuation report, share it with them, and the valuation standard requires you to say, talk about, or disclose many other issues for which there is no field to be filled in those valuation reports. That's again something that needs to be standardized. There needs to be more knowledge sharing with banks, interactive discussions with other stakeholders, and telling them on how those fields which are missing in your reports, how that standardization can be done for the reports to be more complete, more elaborate, and more helpful in the sense that they can be uh, overseen by a regulator as well in case of any problem in future. So over to you, Sahil. I think that's what I would like to share.
Thanks a lot, Ankit, for giving us a detailed discussion presentation upon the valuation ecosystem, the transitionary phase that we are in as far as the valuation and valuers are concerned in India, and the draft valuer bill, which is as we speak under process. So having heard on this, let's quickly move on to the discussion on the Standing Committee on Finance chaired by Jayant Sunaji. And I would like to request Jyoti to run us through that committee report. And if you can, Jyoti, present to us your key findings on that report and run us through a few of the discussions which have been made in detail in that report. Jyoti, over to you, please.
Thank you so much, Sahil. So I think I will cover two aspects, from the report. One is, of course, the recommendations for COC, okay, to strengthen the COC. And second would be how to speed up the process. And I'll just touch upon that slightly so that others can also cover that. So I think it is not in dispute that COC is one of the important stakeholders. In fact, they play an integral role, and that's why under Section 28, there are lots of things that the resolution professional cannot do without permission or consent, rather I'll say consent of majority of the COC. Now, commercial wisdom of COC, I think, has been very well captured in several of the judgments, whether we start in 2019 from K. Shashidhar to SR, or very recent one, which is Ghansham Mishra and Pratap Technocraft in this year. The recommendation that are there, the 4 key recommendations that are there, in the report is one, to bring in a code of conduct for COC, because they are one of the most important stakeholders. They are the one who will decide who the IRP will be, who the RP will be. IRP in case it's a Section 7, and then change of RP. They are the one who will decide which resolution plan to take in, and ultimately they of course put vote on the resolution plan. What will be the haircut? I think much debated topic after Videocon judgment. Okay, so since everything is in their hands, it is very, very important to bind the COC also with a code of conduct, like we are strengthening the framework for resolution professional, who is one of the key player, but ultimately a lot of dependence on COC, because except for running the day-to-day operations, I think for all commercial decisions, the RP looks at the COC. So one is that whether there should be code of conduct. Second is the discussion has been, again, whether there should be some regulation as to whether the IRP is to be changed to RP, or the same IRP needs to be, sort of continue as RP, and if there is any need of change of RP. So there is a lot of discretion that the COC has. But my take on this is that, are we not then interfering with the workings of the COC when we talk about the entire commercial wisdom is in their hand? They are the one who can appoint IRP or change the RP. Then I do not know how far can we regulate this aspect. Third is, and the most debated one, I think, is the haircut. Now, I have a lot to say on that, because I was part of Synergies Dure, which was the first matter in the country where the haircut was 95%, okay, 94% as recorded in NCLAT. Believe you me, I fought from NCLT to NCLAT, filed several applications, whether it was about constitution of COC, whether it was about related party transfer to a third NBFC stepping in as a 78% creditor, or whether it was such a large haircut. But we were thrown out at every stage. And I think what was being told to us that at that point of time, though there were not SR judgments and K. Shashidhar's judgment, but it was very well captured in NCLT and NCLAT order, that it is the commercial wisdom of COC. Okay. Now, so what has happened to commercial wisdom now after 4 years? It still remains same. In 2017, there was a 94% haircut. In 2021, there is a 95% haircut. So what is such a big, hoo-halla about, that Videocon judgment has taken, except of course, the confidentiality issue, which we are saying that, they had liquidation value, but back then in 2017, the liquidation value was known to the bidder also, right? And there the bidder was also a related party. So I see that it's a full circle. But I think what I still believe in is that while I may have some scars as far as Synergies Dure is concerned, but at the same time, we cannot really undermine commercial wisdom of COC, where we have got 80% and 110% of the liquidation value, whether it is Binani Cement or other matters. So I think it again depends upon what is the asset value, what is the asset quality. Ultimately, when today also the COC will get to know the liquidation value, once they receive the resolution plan, they will vote on it depending on what the liquidation value is, right? So I don't think much has changed, and my personal view is that this haircut, what percentage should it be, should not be regulated. The reason that it should be left to the commercial wisdom of COC. Otherwise, on one side, we are setting up, judicial precedents to say that it is COC's, commercial wisdom. And then we are cutting hands of the COC to say that, look, you eat with your hands, but we will cut your hands. It doesn't work like that. You can't regulate. It should not take the same situation which was in OTS, or there were S4As and all of that, where you need to so it should not be regulated. Otherwise, there is no commercial wisdom, there is no discretion. So I'm slightly personally against putting any regulation. You can have a code of conduct for sure. They should be bound by confidentiality. They should be bound by other aspects, but we should not interfere, because we have RBI circulars and regulations to say how you lend the money, but we don't really regulate them and spoon feed the lenders at each stage to say, this should be there, this should not be there. So personally, I don't think this is gonna fly in that sense. And the last, of course, is being that that sometimes they accept bidders at the last moment. The resolution plans come in late. They, sort of deal with it at any point of time that they want. Again, I think in Binani, it was highly contested, right, by Dalmia, to say that how can you have somebody at the last moment. But I think we are setting up a judicial precedent where maximization of value is taking precedence over procedure in some aspects. So while we can regulate it, it has been regulated in the code itself. Regulations say so. But I think we have done away with some of those very hardcore procedures just for value maximization. Very slightly, I will just touch upon, the standing committee report on saying which are the observations and recommendations to say that what can be done to speed up the process of resolution, and then I'll let others take over. One is, of course, there has been debate on what is the role of resolution professional and whether the fresh blood should be brought in order to ensure that without any practical experience, just because they're qualified, will they be competent? But I think we need to make room for everybody. Not every case is complex and not every case is high stake. And unless we put those, on the churn, they will never become experienced. So I think that was one aspect. Second is, again, it talks about the CUC, professional code of conduct and other aspect that I just covered. Then a lot of hue and cry about NCLTs, overstressed, and then leading to delays. That is another aspect that is covered in this. And it has been recommended that there should be sanction strength and there should not be any delays in appointments. Then again, like what you touched, Sahil, about that there should be flexible resolution plans, that at the stage of resolution itself, whether there can be different businesses handed over to different new owners. IBC ecosystem digitalization, again, you spoke about, I'm not going to touch on that. Then it also says that in order to strengthen the entire resolution, there should be pre-pack of MSME leading to then the general corporates also. Cross-border insolvency, bad bank has come in, and then strengthening home buyer rights. So these are some aspects that are covered in the report. And I think, as I said, that it's a very good move because we have entire data in front of us. We know where we have landed in, these 4 years, 5 years, and what is the way forward. What is good is that our regulator is very vigilant. The government is very vigilant, and they hear the market and they take appropriate steps at that point of time. In 2016, also very hopeful that IBC will do wonders, and that hope still continues. So thank you so much.
Great. Thank you so much, Jyoti. Couldn't agree more with you on the point that we've seen a full circle right from Synergies Dure to now Videocon. And again, the haircut is actually dependent upon the asset quality and the stage and state in which the corporate debtor is at this point in time. And our chairperson IBBI, Dr. MS Sahu, has also clearly mentioned that before admission into NCLT, only you have seen that the debt is 5x to your asset value. So IBC has done actually wonders in increasing that resolution, and the recovery maximization has taken place because of the advent of IBC and not the otherwise. Ultimately depends upon the commercial wisdom of the COC, and many a times we have seen that this commercial wisdom of the COC has been intruded or commented upon at the NCLTs, and in any which ways we have half strength at the NCLT, and that too intruding into the commercial wisdom of the COCs. So Mahima, what are your thoughts on all this, and what is the way forward, and can there be a quicker way to turn around things, and if you have any other additional points also to add on the Jayan Sinha report along with this NCLT infrastructure bottleneck at this point in time, Mahima?
Audible?
Yes, you are.
Yeah. A very good morning to all my co-panelists and the attendees, and thank you, Jyoti, for taking us through the standing committee report. I would like to first dwell on two themes, which are the topics of our discussion today, and try to sort of talk on the interplay. One is the valuation, and the other is the role of the COC. And in fact, it is connected to the topic of timely resolution as well. Yeah, we all are aware that under the CIRP regulations, it's the RP which is responsible for appointing the registered valuers. And this is something I'm talking out of experience in various cases. One issue which has led to delays in the resolution process, and which is, to my mind, a gray area, which eventually will probably need some guidance from the regulator also, is the role of the COC in the valuation. Now, the RP has to appoint the registered valuers, is responsible for conducting and driving the entire valuation process. But in a lot of cases, we are, and more so recently, we have started seeing a lot of COC members question the valuation report. Now, if we pause here for a moment and think about the purpose of valuation, the fundamental purpose of having a valuation done is to essentially enable the COC to arrive at a considered decision on the resolution plan. Now, so the question is, what say should the COC, and whether the COC should have a say at all in the valuation process or not. Now, in a few disciplinary orders passed by the regulator, we have observed that the regulator was of the view that the RP should be conducting the valuation process independently and should not abdicate his role in favor of the COC. But the practical challenge that we have at least experienced in a few cases is where the COC questions the valuation, and at times would also want the RP to appoint a fresh valuer because they are not happy with the valuation report, or they believe there's some fraud or something wrong with the valuation report. So the question is, in these situations, and I'll be happy to have the views of my co-panelists who are from the from a valuation background. What should a valuer do in that circumstance, and what should the IP do? What should the resolution professional do in a situation like this? Now, the problem is, again, it leads to a delay in the resolution process, because if there's continuous to and fro between the resolution professional and the COC on the question of valuation, the matter lands up in court. We don't have very many precedents on whether the COC should have a say in the valuation process. So that is one area which I feel probably going forward we should be able to have more clarity on. The second point that I would like to talk about is the haircut, and that is something Jyoti touched upon briefly, was whether the haircuts should be benchmarked. Personally, I fully agree with Jyoti, and I'm sure my other co-panelists would also believe that haircuts, let the market forces play their role as far as haircuts is concerned, and we should probably avoid and we should be very cautious in being overly prescriptive by benchmarking haircuts that 95% is not good and an 85% is good. And there, what we need to bear in mind is to go back to the fundamental object of the code, which is resolution of the corporate debtor. And in so many cases, we've been the judiciary has held that the CIRP process is not a recovery mechanism. It's more a resolution. It's a mechanism for resolution of the corporate debtor. So even if, say, with a 90% haircut, if the lenders are willing to take that haircut in their commercial wisdom, if a CD can be turned around, in my view, honestly, keeping the objects of the IBC in mind, I don't see why that should be that much of a concern. And again, I for one would be very, very cautious and would prefer not being overly prescriptive as far as the commercial side and the commercial assessment of the plan is concerned. The third thing that I would like to talk about, again, very close to all the hearts of all litigators, is the delay in the process. And there we are all aware, there are capacity issues. It needs to be augmented. There are vacant posts waiting to get filled. But one of the other issues which we constantly face, and again that is something which I guess with further amendments will get clarified, is uh, appeals against plan approval orders. Now, what happens is, of course, when the plan is being considered, it's essentially the COC which has a role to play in it. The plan is filed, it's approved by the COC, lands up in NCLT. The judicial process itself takes a lot of time. After months of waiting for a plan to get approved, when the plan is finally approved, suddenly we see, various appeals being filed by parties who were not before the NCLT in the first place. Because what happens is, a lot of times these stakeholders, obviously because they're not part of the COC, they are not privy to the terms of the plan. And eventually, when the plan approval order comes out and it contains certain details about various aspects of the plan, we have like these multiple appeals filed before the appellate tribunal, which further, leads to delay in the process. So one thing probably which going forward will need to be clarified, whether by way of amendments or whatever, is how to tackle these these appeals, especially when the code section 61(3) specifies what are the circumstances in which the plan approval orders can be appealed against, which is only when the plan contravenes the mandatory provisions of the code, or if there is a material irregularity. But what about cases where, say, 5-6 OCs who were not aware about the details of the plan suddenly approach the NCLAT? Should they have a say? Should they not have a say? And how to tackle these appeals? Obviously, then they end up landing in the Supreme Court as well. So I think these are few issues, and probably as we go further in the discussion, I'll pitch in as and when needed.
Thanks a lot, Mahima, and great that you brought up very interesting points as well. I mean, it's the practical insights that we would like to discuss and deliberate upon, which would be a learning experience for all of us here as well as the audience. Ankit, would you like to give in your perspective upon the point Mahima touched upon as to what is your say on what and how should have been done by the valuer or the COC at in wherein valuation report has been challenged? I'm sure we all face this often, and there are definitely questions asked, and the valuer has to justify the valuations done by him, and again the procedures laid around. So, Ankit, anything that you have seen in your experience, and if you would want to answer.
I will share my experience with this, and I think that will perhaps give a perspective to what the process is. So the legal process is very clear. The legal process is that the duty to appoint valuers is of the insolvency professional. The duty to provide information and provide support to the valuer to do a just valuation is also for the insolvency professional. They are both supposed to work together and try to find out a value to the assets. The COC has only one mandate, where the COC is supposed to give the financial approval for the appointment of valuer. In some circumstances, we see that the COC talks about or recommends that you appoint this valuer, and they recommend to the resolution professional or the interim resolution professional or the liquidator that this is the process that we will advise you to follow. And in those processes also, the idea is that the final decision is with the IP or the resolution professional to appoint the valuers. Giving the information is also the IP's duty. Sharing the draft report, at that stage also, the valuer is supposed to share the draft report and the final report only with the insolvency professional, with the liquidator, with the resolution professional, not with the COC directly. That's also very, very clear. It has also been talked about in the by the various IBBI disciplinary orders. What happens after that is that in some occasions we get the understanding from the resolution professional or the liquidator that the COC has certain questions on the valuation report. At that point in time, we usually draw a line. We say that we will not be able to discuss the draft valuation report with the COC. We can only explain, we can only talk about what we have done in the valuation report once you've issued the final report. And that is what we have done in many cases, where we have had a full-fledged, we have been invited as a special invitee as part of the COC, and we have gone through this final COC report with the members of the COC who have given the declaration of confidentiality to the RP. And at various occasions, legally speaking, the interest of the COC members is is based on the valuation report. Now, say there is a dissenting creditor. The dissenting creditor owns a security, and that security is part of the company's assets. In that case, if I'm giving a value as a value to that asset, which is an X value, the amount of money that that person can take away is totally dependent on that valuation report. In case he chooses to relinquish the asset to the liquidator, or through the, or he, as a dissenting creditor, gets his value through the resolution plan. And that is the litigating factor, that what is the money or what is the value of that particular asset. Unfortunately, there is no way to change the final report that one has issued, but in many cases, we always advise the resolution professional to reach out to the COC members, make sure that you have all the details that are available with the COC members that can influence the valuation decision. Now, the problem comes in where the information has not been received or not available with the RP with respect to that asset. The valuer has given a value, say, in many occasions, we don't have, say, the data on trade receivables, and we have no other option but to give a zero value. In that case, if trade receivables are a security for a descending creditor, then that person will perhaps get nothing because we have given a zero value. But if at the same time we get some information as a valuer, then we can always give that valuation, put an amount to that asset, and basically make a better report.
Thanks a lot, Ankit, for your perspectives on Mahima's question. And I would like to chip in by giving mine too. It is not unusual, while I agree with you, Ankit, that the discussion on the report has to and only has to happen on the final report, because that is only when it is presented to the COC via the resolution professional. And it is a usual norm in the, at least in the mid to large cases, that the valuer has been invited to a COC to present his report and his findings, bases, assumptions, and the key value drivers. And there have been instances where the questioning and cross-questioning and discussions and counter-discussions have happened. So I think the onus is on the valuer to satisfy the bases and the assumptions which have formed as a premise to the entire valuation. And the provision in the code of an appointment of a third valuer is only when there is a significant difference in the two valuation reports. So unfortunately, there is no provision which says that, okay, I'm not happy with valuer A, let us probably go and get a valuer C. But the fact still remains that if there is no significant difference between valuer A and B, and as much as you might not be happy with a valuer A, there is no provision to appoint a valuer C. But yes, if there is a difference of significance between valuer A and B, a resolution professional is free to appoint a valuer C and independently have a look at the valuation of the asset. So this is my limited inputs, Mahima, on your question that you touched base upon. Great discussions on that. So I think let's look at it from a different perspective. I think what is happening in India at this point of time is that there is a startup ecosystem which is blooming. You have the unicorns we talk about and we see and we read, and the tech startups. And on the other hand, we have the IBC. So IBC has seen a lot of M&A interest from domestic as well as international players, may it be strategics, may it be funds, or may it be international entities looking at IBC as an entry point in India. So Kiran, what are your thoughts on it as an M&A specialist? What has your experience been? If you can walk us through examples when you have been advising your clients or you have been advising the lenders, and if you can help us walk us through this entire process of the distressed asset space, which is so fast and evolving in India at this point in time. Kiran, over to you.
Thank you, Sahil, and very interesting perspectives by the co-panelists. So I'll take it in a very simple manner. It's a basic law of economics of demand and supply. So when we look at the situation in India today, right, there is a huge supply of distressed stress assets, right? And who can lap it up? That's where the demand is. So from perspective of what has happened the last 4-5 years, especially 4 years under IBC, initially, there was a lot of excitement, domestic players, international players, and we saw a lot of participation in various manners. But when it comes pure play to domestic equity, one has to understand that our country is capital starved, and domestic equity as such is fairly scarce and with limited number of people. And most transactions which happen, there is direct or indirect leveraging. So important participants become overseas players who can sort of, aid this entire ecosystem, support the resolutions, either individually or collaboratively through Indian participants. And as I said, that there was a lot of excitement. We saw a lot of transactions happening in the beginning. But many of these investors have now become cautious with the experience which they have had in the system. Very, very clearly that is seen. There is a fatigue. And one must understand, when it comes to financial investors from overseas, they are organized and they are regulated. They are not strategic people. They have their own answers, own boards to give, own systems and own investment committees, and they have to answer their investors, their LPs themselves. So what has happened, in my opinion, where in the last 4 years, there were a lot of people who entered India. They have also done transactions, which is a very big positive. And I'm specifically talking from an IBC perspective. Outside the IBC also, stress resolutions do happen, and they are continuing to happen in some of the interesting sectors. But there were a lot of fence sitters. Unfortunately, if you really take an objective look today, those fence sitters have gone back behind the fences. They're no longer fence sitting. So that's the fact we have to agree, appreciate, and see how we can rework our systems in a manner that more and more participation happens through global players. That is where the entire resolutions, the value of the resolutions will go up, and the COC, the other stakeholders will find themselves satisfactory or satisfying resolutions, and they are able to recover. The other important thing is business cycles, timing plays a lot of role. I think Sahil, you yourself touched upon it when you were introducing. Very simple cases in points. You look at steel, and in fact, Gauri also had given a very good introduction. So Crisil has also a report on that. People who participated in steel, because of the way the cycle is today, they have been able to turn around the companies faster. In fact, since I'm also sharing my experiences, so I have been a part of a couple of processes earlier which were done outside the IBC. Also, one process inside the IBC, wherein the recovery or the resolution offered was smaller. And I'm talking of just a couple of years back or 1.5 years back in the steel sector. And at that point of time, the lenders did not go ahead with those offers. One offer got litigated. But today, in the last 3-4 months, when the lenders have come out and done the processes again, they have in fact had better recoveries. So almost 20-25% better recoveries. So what's important is also to understand, what is the cyclicality of that particular industry, because we keep on talking about, and even the judiciary keeps speaking about the wisdom of the COC and the COC, right? The COC has a lot of responsibilities, and one must understand who is the COC. A lot of these COC members are regular bankers who are doing regular work, their banking work on a day-to-day basis, and this is an additional responsibility which they have been given. They may or may not be equipped to manage such type of responsibility. One has to sort of be, sensitive to that point, because ultimately resolutions are going to be an outcome of how does the entire ecosystem function. I think someone also spoke about, I think, the receivables part, right? So that is another aspect. Why does a resolution value is lower? Valuation is just a means. When the data made available to potential investor itself is not intense, not detailed, not to the mark which investors want, like how it would happen largely in a regular M&A, may not be 100%, but at least 80%. Many of the matters, many of the circumstances, many of the cases which we see, there is hardly data, and then this data being not there, that gets factored in the value which is getting offered, right? So and we also spoke about a code of conduct for the COC. I personally feel, before a code of conduct, maybe there has to be some mechanism in which the COC members are trained. There are data gaps. There is an experience which some banks have, some of the other banks may not have, or maybe the larger cases is where people manage it centrally. But what about medium cases? What about smaller cases? Ultimately, that is also the dollar lent, right? And the dollar has to be recovered. So there has to be a lot of training in terms of training, learning, experience-based things. People who are participating in the COCs Maybe all banks should have specific departments, not general departments. Some of the banks already have, but maybe all, because this will lead to better negotiations, better discussions. Even some of the problems which the valuers have highlighted, they will also get easily resolved, because somebody who has the experience, who understands it better, comes from many such cases, will be able to discuss and effectively conclude. So clearly, from a perspective of how M&As are operating today, foreign investors, as we clearly know, at this point of time, especially in IBC, the participation is lesser. Certain sectors, thankfully, are doing well, but certain sectors possibly could have done better, like power and all. Even we spoke about a case which was in the consumer space, right, which is getting challenged at various courts. So there has to be a mechanism, maybe wherein the COC participates in the turnaround. That is very important, because you may get an upfront number which may be smaller, but if the company is able to turn around, if you are confident that you are giving the company to an investor who has the capability, competency to turn it around, then the COC should be able to participate in that turnaround. Nobody stops them actually, and they need to negotiate that and reap the rewards out of it over a period of time. For example, a consumer brand today, if you're getting a value for the assets, and because the brand is beleaguered today, it is not getting factored in the valuations. But if that brand has a lot of intangible values, right? And if the companies turn around, there could be immense value which would come to it, and that the COC should be able to, not only COC, any stakeholder should be able to participate in that type of recovery, and hence gain some benefit. That is how the recoveries are going to be higher. Recovery is not going to be done through pure sales. Pure sale, we are only going to get an X value. But if the banks, the stakeholders are able to participate in the recovery, I'm sure over a period of time they'll be able to get better values. Lastly, I think I just want to sort of touch upon two aspects. I think there was a topic of, I think Gauri spoke about secondary market participation. I think that has becoming more and more crucial, frankly. Unless there is a well organized and a secondary market which is starting to mature, that is where there are players who understand this business will come into play. They will give the valuations. There will be if there's a market, if there are market participants, and if there is good data availability transparently, this is where this market will flourish. Because what we saw, some of the transactions was in the large cases, but what is important is that it goes down granular in some of the medium cases, at least. That is where people will see a lot of traction, and valuation value of and recovery will start going up. So that is one thing which I wanted to talk about. And the last thing I honestly want to talk about is the recovery to the OCs. See, what is happening is, I think we need maybe more analysis on what is really happening to the OCs. Please understand, when the initial introduction was given, we spoke about the coming stress in MSMEs and retail. But many of these are OCs, frankly. If they're not recovering from the larger players, there is going to be a cascading effect on them, and someday or the other it will come out. So slightly, I think time has come with 4 years of experience. Actually, people can take a step back and try to look at it in complete thing, and try to do an wholesome correction on some of these points, the legal disputes, the timing, who is the COC, what can the COC do. But yes, I'll tell you, India continues to be of interest. That goes without saying. People like the country even today. People dislike the uncertainty. If the uncertainty is minimized and investors can factor in more unknowns, I am sure valuations will go up and more transactions will come. That's what I'll say. Thank you.
Thanks a lot, Kiran, for your insights on this. And yes, the lesser the uncertainty, the higher the maximization of value, and the more the data availability, the transparency, I think the entire ecosystem will flourish. Yes, India has been talked about, is, and I'm sure shall continue to be talked about, because it is the land of opportunities and the world has its eye on us. There have been large players, ArcelorMittal being the most talked about, looking at an entry point in India. You yourself talked about a steel plant and the cyclical nature of business. It depends upon what point in time that you have entered into that business, being a trend. Even if you see the IBC, the resolutions, it has been sector agnostic. There have been certain sectors which have seen traction and interest amongst players, both domestic and international, while there have been sectors which have not seen significant interests. So this is part and parcel of the game. They might have been different today, might be different again tomorrow, because again of the cyclical nature of the business. So I think let's come to the perspective of a resolution professional. Ankur is a resolution professional amongst us, and let's hear it from him, because an RP is kind of a centric into the entire ecosystem, who runs the entire process, has to handle and manage the COC on one side, the resolution applicants, the valuer, the NCLTs, and all stakeholders, so on and so forth, and look forward to thrive the business of the corporate debtor as a going concern, and look to maximize the value and take up a resolution. So Ankur, what are your thoughts, being representing the resolution professionals, being a centric of the entire ecosystem? Over to you, Ankur, on this.
Thanks, Sahil. Thanks all the fellow panelists and ASSOCHAM for organizing this series on the IBC. Much needed discussion during this era, where the almost now 5 years of the IBC code will be getting completed in maybe another next week or so, and a lot of changes, lot of experience. So it started somewhere in 2016, 17, 18 was a 18, 19 was a big chunk. It get a IBC get a revival sort of a things when the RBI come with this list of 12 accounts. It give a boost to the, then lot of cases happened. 2018-19 was a very busy year. Then 2020 and 21 now, because of the pandemic, things have little bit slowed down. The existing cases are going on, and in between out of those 12 cases, still couple of still hanging on. And in between the stakeholders which are during this IBC ecosystem, RP is obviously there, IBBI is there, COC or banks are, financial creditors are there, operational creditors, and the valuers, which played a very important role, because the entire resolution plans and other things are based on what is the value for a particular company or particular corporate data or particular asset is to be there. So I will not go what is the process and everything of the appointment, which is all the learned panelists have already briefed and everybody is aware about. I come with some practical problem which as a lawyer, as a RP, we face during the CRP process, and what are the probable things. First of the things I can say regarding the appointment of valuers. So the two valuers have to be appointed, the quotations have to be appointed, made, invited from the valuers. Though it is like my fellow panelists earlier said, that it is the RP who has to appoint the valuers. But a lot of times it's the CUC members who insist that, okay, this particular persons or who have been known, so it should be appointed. And so I think as a RP, they have to go with their independency, and based on the experience and the fees of the particular valuers that need to be appointed. And then there is a host of compliances to be done, because initially when the IBC introduced, a lot of people were working in their proprietorship name. So a lot of RPs have appointed, suppose in the issued the appointment letter in the name of say ABC valuers, where as per the regulations at that point of time, the letters and appointment has to be issued in the name of the registered valuer only. And a lot of RPs have got the show cause notice because of that. So one thing is that whenever we are appointing, it has to be the registered valuer. The second thing what we have seen that technically is the two valuers to be appointed, but practically it is the 6 valuers, because one is for the land and building, one for the financial asset, and one for the plant and machinery. So in most of the cases, land and building and plant and machinery can be the one person, and the financial assets can be another person, or it can be a 3 separate person. So as a RP, when you are appointing any RP, you have to be clear which are the 2 sets of the valuers, and what is the proportion of fees to be paid to them. Otherwise, how it happens, you appoint one person and then 2 valuers also chip in, and then the proportion is not there in the fees and the letters which you have submitted to the IBBI or COC. So unnecessary certain complications. So whatever the appointments are done as a RP, one must be clear, okay, this is the two valuers out of, in these two valuers, these are the three set of valuers each, or two set of the valuers, one for the plant machinery and land and building, and for the financial assets. So from there, the appointment things can take over. The other problem is normally how it happens. The valuation is to be done as of the CRP date, and you appoint the valuer maybe another after say 4-6 weeks or some time. And by the time, if it's a dormant company, it's a closed company, you can just make the valuation on the basis of that particular point of time. But if it's a running company, and if you are a running company and you have to do a stock valuation or financial asset valuation, the assets will be consumed over the period of time. So as a valuer, the problem, as a RPB is the problem, if we take the position as of the date of the CRP, and the valuation completed say within after next 3-4 months, and in that point of time, whether it's a bank balance or the stocks or something have changed the hands. So how far that valuation is on the CRP date is relevant at that point of time, or should we have the options to consider that whatever the value of the stocks and everything have been consumed, and whatever the further stocks will be taken, something in the valuation can be built up accordingly. The idea is that because this is the valuation on the basis of which the entire CRP going to be considered. The other point is normally how it happened. Sometimes, particularly during the pandemic, when the CRP itself has stretched over a period of time. So initial period of 180 days or 270 days is something which is not practicable because due to the lockdown and exclusion extension of period. And now most of the CRPs are well beyond more than a year or 1.5 years because of the exclusions, etc. So whatever the valuation which has been done almost say 1.5 years back or 2 years back, how much relevant is there? Whether the COC or the RP can have a more updated valuation with the same valuer, or they have to go with that valuation only, because it may be probability that the asset over the period of time have deteriorated. Suppose I take a case of a land block or land parcel is there. Whatever the valuation, maybe it happening in the 2019 end or before the pandemic, it may have come down at this particular point of time. And if we, because whatever the resolution plan or even in the liquidation, this valuation is the basis. Though in various court judgment, it has been said that the liquidation value is not the barometer for the resolution plan, but as a COC, normally they consider it, this is the benchmark. The plan should be over and above that. So this is again a very practical problem. So whether as a RP or as a COC, they can mandate a updated valuation considering these factors with these things or not. The other thing is from the valuer perspective also, and from the RP, the problem happens in a lot of the cases where we have seen that the details of the assets itself is not available, or assets are so far-fetched. Suppose I am sitting in Mumbai and some part of the land is suppose in Chennai or say some far area of Kerala. And the fees which are being paid to the, I'm more talking about from the Sahil point of view, the fees which are being negotiated with the valuers. So certainly these aspects are not considered. And somewhere because of these factors, the valuation, the way it should have happened, may not happen in that way. So it is not that they are compromising something, but then they do the valuation on the basis of certain documentation, and more particularly the travel restriction during the COVID period. So again, these valuations have suffered certain things. Obviously, sometimes in some areas, corporate debtors or the promoter doesn't give the details of the entire assets or the document. Suppose they have to value some land or something, so obviously they have to see what are the title documents and everything. So many times even the RP is not get hold of those documents. Banks, if they are having, they don't share it. So getting the market value from nearby areas, so it become a very subjective thing. And a lot of times, like my previous panelist also pointed out, that there is a normal complaint, okay, this valuation is very lower from the COC side. And if the promoters are there participating in the meetings, and when the resolution plan comes, they say, no, I can offer much better than this. So keeping all these things, I think the evaluation things has to be a very clear cut. We have now a very good process of the registered valuer. At the same time, certain more guidelines need to be defined or issued by the concerned authorities, so that a framework for how the valuations to be done. Normally, it is given that internationally accepted standard. Itself, it's a very vague thing, because there are different methods for different things, and it gives a very so when we are talking about the IBC, so we can come with the frame lines. Okay, for this type of asset, these are the methods which should be deployed, and these should be the way, so that it can be a very transparent way. Second thing, I think what we are discussing about the Jayant Sinha committee report. So they have dwelt upon the various review of the IBC, and they have proposed the sort of the Institute of Resolution Professional on the line of the ICI, ICCI. I think that will be a welcome move, because now IP profession itself is becoming come to a much mature position. Though I think more than 3,000, 3,500 IPs are there. I tell you, when I done my company secretary way back in 97, then the company secretaries were hardly 5 to 6,000 or 7,000 and that point of time. So this is a good suggestion to have a institute which regulate the things for the RPs in a better way. The second thing, what the Jayant committee, Sinha committee has recommended, code of conduct for the COC. My earlier panelist also said that before the code of conduct, there has to be a proper training mechanism for the COC members also. What we face the problem, and I think that banks also, financial institutions, they have faced the problem, because they have not centralized mostly, whether it's a head office or as an asset recovery branch. And there is a team of 10, 12 people which have come from a different backgrounds. And at a time, if you go to any asset recovery branch, or if you are interacting with them, on a given day, some 10 to 12 COCs are being conducted. And nowadays, all the COC, 95% are conducted through the VC. So when we are having a physical meeting, then the span of attraction is obviously much more. And when we are having the COC of online, the span of attraction reduces, and so many meetings are happening. So the senior persons don't have that much time to attend each and every COC meeting. So they obviously appoint, nominate some junior persons to attend the COC meeting. And then how it happens, it becomes just a formality that the concerned person will be attending the COC meeting. He is not able to take any decisions or anything. So whatever will happen, it will be go on the e-voting things. And with our experience, there is no time limit for the e-voting. So if you keep it 7 days, 10 days, 20 days, 30 days, even the e-voting goes for the 45 days also. So it's, and as a RP, you can't say that I cannot extend the period. And more so when the environment is like this, because of the pandemic and the Supreme Court judgment, there is no clear-cut timeline when the CRP is ending. So different applications are being filed in the NCLT. The judgments are not coming. And so for everyone, it become a more convenient thing. Okay, take your time, whether for the resolution resolution professional, for the COC. And that's how the things are getting extended. So I think one of the things should be that, like in good older days, under the SURFACE, there is a provision that a person below the chief manager cannot issue the notices under section 13(2). So it has to be issued by chief manager and above person. So similar provision can be come into the COC also. Okay, certain person above only can attend the COC. There have been guidelines that the person who is attending the COC should be in a decision-taking capacity. But with the e-voting, we should keep a cap on the number of days the e-voting should happen. There can be bifurcation between the various decisions to be taken in the COC. For the resolution plan, a longer period can be prescribed. But for certain other matters which are more in the routine in nature, but the COC voting is required, I think 4 to 7 days should be the enough. Within that, the concerned financial institution should take the decisions. It should not kept hanging on those things. The other thing as part of the COCs happen, particularly with the banks, the person keep on changing. So suppose a person from the branch is attending, he may be transferred, or suppose one day another person from the regional office or zonal office will come and attend, and because they are not aware of the background, so again the things get extended and extended. So this is again, I think in all those things, these are the experience which may have come to the knowledge of the Jain Sinha committee, and that is why they have said that there has to be a code of conduct for the COC member itself.
Sure.
So these are the few points which I think the government and IBBI sees of these matters. The other things, as a RP, I will just, I think I have raised this question in the last thing also. And again, these things, there has to be also some guidelines from the IBBI regarding the fees, etc., both for the minimum fees or something for the valuers, for the RPs, etc. So that how it happened, like in the Jain Sinha committee also said that appointment and change of RPs, there should be some guidelines. It should not be left to the only the choice of the COC. There has to be some transparency, because in this process a person is appointed as the IRP. He suppose the financial institution or somebody, there is a discussion on the fees, what they are proposing is not agree, or for some other reason that IRP is not to be continued, and the new person who is RP is to be appointed, the application is to be filed in the NCLT, and the entire process, it will take 3-4 months. So what the initial period of 180 days, the IRP is continuing, has to work. So one thing he knows that he is only for a temporary period. At the same time, he is to continue with all his duties. So there is a lot of conflict, and if you see in the NCLT, lot of cases are being filed by the RPs or with the banks or the other lenders. The always the discussion or the litigation is all about the payment of the fees, whether the fees is agreed or not, or whether the fees is not paid for a longer period. So these are all the things where the certain guidelines need to become. I think a welcome move has been done by at least by the honorable NCLTs. Now, in the case of mostly with the operational creditors who have filing the applications, NCLT while admitting the application itself impose certain cost on the operational creditor or the applicant, that he has to pay a certain deposit amount with the concerned RP. So at least he can meet the day-to-day expenses. So these are the things I think the government and the IBBI sees of these all the difficulties, and it's not only one part as a RP or as a COC. It's every part has in certain problems, and I think last 2 years we have lost because of the pandemic. Otherwise, the situations must have improved like anything. But now I think the situations are improving with the government is and IBBI is always very proactive and coming with the regulations and making the changes as and when required. I think with these suggestions and everything with the Jain Sinha committee, things will improve for better.
Great.
Thank you, everyone.
Thanks a lot, Ankur, for giving your practical insights on the valuation as well as the COC. And to take it forward from here, there is a question, and I will take the liberty to ask Deepak Ji to address to this question. It's a question and a suggestion both. And with this, I would like to encourage all panelists to, all participants to throw questions at specific panelists or in general, and I would encourage them to participate. The chat box is open, and we already see a few questions here. So Deepak Ji, it's a suggestion and a question saying that why can't the bank hire insolvency professionals as their advisors for better representations in the COC? We already heard Ankur talk about not the best representations happening from the COCs, the seniors are not available due to their schedules. And along with this, if you can also take us through with what are your perceptions on the roles and responsibility of the COCs and any inputs on the suggestions for timely resolutions for the same. Deepak Ji, over to you on this.
Am I audible?
Yes, now you're audible.
Good afternoon to the fellow panelists. Before I take up the question, let me also have some feelers about today's discussion. I have some more queries to the valuers, especially who are representing the valuers community. I find some challenges, practical challenges. So let us address this. And I have something to add to code of conduct for COC. First, I'll take up the valuation parts. The words terminology used in CRP is fair value and liquidation value. And when we move to the liquidation, the flexibility has been given to the liquidator to use the earlier valuations as far as possible. But there the terminology used is as a realizable value. So that is one thing I would really like to know. Broadly, we would know what is liquidation value, what is the realizable value, but what are the finer differences? Like how do we address this? Because if I'm using the same valuations which were there with me under CRP, so how do I come to a conclusion what is a realizable value? That is one thing. And there is another provision under liquidation regulations when you are appointing liquidators, you are appointing the valuers. The valuers have to do valuations under uh, regulation 32A to F. There are different standalone basis, slump sale, and last is the going concern as a business or as a company. I have tried these combinations. I appointed valuers, and I really asked them, please, under liquidation regulation, you please give me those values. But I really didn't get it. Probably the valuers are also not prepared to understand these concepts: slump sale, collectively parcels, going concern. So I really would like Ankit or some other who's representing the valuers community to address, guide me on this. The other thing which I didn't get from the valuers is, suppose it is a leasehold land and for example, I say it's RICO in Rajasthan. They are giving their lands on the lease to the companies. So whenever we appoint the valuers, we request them to find out what are the encumbrances on that leasehold lands in the office of RICO, because only then the exact value of the asset will come out, and on the basis of which the resolution plans are being accepted by the financial creditors. But I didn't get it. The valuers would say, no, that is not within our role. We will not be able to find out what is happening in RICO office. So what they will do, they will go to the registrar's office. What is the amount at which the deals are being done, and we'll get the market value. And the liquidation value will be, of course, some 20 to 25% below that. So we don't get the exact value. Doesn't it come under the role of the valuers to find out the encumbrances? That remains a very open chapter, because the valuer has given a fair market value, but once the financial creditors are examining a plan on the basis of that fair value, and resolution applicant is discounting in his resolution plan those encumbrances. So I have not been able to address that issue. Request valuers to please guide me. This was on valuations. And regarding code of conduct, my fellow insolvency professional, Mr. Ankush, has already suggested there are genuine problems. But where is the code of conduct for home buyer COC? Can there be any code of conduct? I mean, it is a nightmare. We call it as a professional challenge, but it is a nightmare. Can there be any code of conduct for home buyer COC? There are many cases where IRPs are continuing as IRP for 2 years. Not even a single resolution has been passed. Appointment of professionals. Leave aside the fees of the insolvency professional, but not even the fees of professionals has been approved. We have appointed the professionals, valuers, auditors, but we are not getting it. Where is the code of conduct? Can there be any conduct for the home buyer COC? These are 2-3 open questions. We can take up these questions if I can get answer from the Ankit and other valuers on my queries.
Yeah, thank you, Deepak ji, for being a panelist as well as asking questions, and it will be only add on to the discussions.
These are the Sahil practical challenges we are facing as an insolvency.
And these are the practical challenges, and that is the reason why the audience comes and attends to have a practical insight of the entire process. Ankit, would you like to address this? Would you want me to chip in as well?
For sure. So, starting from the first point that Deepak ji shared, the difference between liquidation value and realizable value. So, how IBC regulations are structured is that in CIRP regulations, the requirement is to compute fair value and liquidation value, and both fair value and liquidation value are defined within the CIRP regulations. Liquidation value is defined as realizable value from the sale of assets of the CD as on the CIRP date. That is the definition of liquidation value given under CIRP regulations. When we go into liquidation regulations, at that stage, there is no definition of liquidation value. All the regulations say there is that the valuer who is appointed by the liquidator is supposed to give the realizable value of the assets if the assets are sold in the manner specified in regulation 32, and that is how the definition, that is how the role is given. So I think it is only an interplay of two sections in CIRP and the only one section which talks about realizable value. The difference is that when you do a valuation and given by a liquidator, the registered valuer is supposed to give the values, realizable values, as on the date of the inspection or as on a recent date. Whereas in case of a CRP regulation valuation, where you're supposed to give a liquidation value, you're supposed to give a liquidation value as on the CRP date. But other than that, the definitions are exactly the same. I don't see any difference there. And I do believe that the whole logic is that in case of CIRP regulations or CIRP process, the idea is to give the stakeholders a number that an independent person believes will be realizable in case the company is liquidated, so that a conscious decision can be taken that in case we go for liquidation, this is the value that we will get. And because we are going for a resolution plan, this is the value that we are getting. And if that value is higher, maybe or more sure short, then the COC can perhaps take a more conscious decision on this, on the resolution plan. That is my take on this one. Coming to the next second query from Deepak ji with respect to valuation under where regulation 32 talks about clauses A to F, talks about how you can sell the assets on a standalone basis, on a piecemeal, on a standalone basis, on parcels, collectively as a slum sale, then the business as a going concern and the company as a going concern. Now here, I myself was puzzled with this question, and in I think last to last year, there was a national conference on valuation, and I just got up and asked Dr. Sahu this question, and his answer is something that I still remember. He said that he can't expect the resolution professional to give the registered valuer the modes through which the assets can be sold, and he said it has to be perhaps a joint effort between the valuer and the RP to find out that how does the market see the best value within these assets. And at many times, the best value is very clearly visible as a going concern. At many times, the best value is not so visibly understandable, and therefore there is perhaps a requirement to give values as a going concern as well as values on a piecemeal basis. At times, you have a structure where the building is so integrated with the plant and machinery that it is impossible to sell both of them independently. At that stage, maybe the valuer has to or should ideally give a value which is collectively a value for both those assets put together. So that is my take on the second part. With respect to the leasehold land, I strongly believe that the valuer's job is perhaps not to start investigating into encumbrances. His job is to look into the encumbrance, but the fact whether there are any encumbrances or not is ideally supposed to be collected by the RP's team, because it is also a very, very essential item to create a market for that asset and for the encumbrances to be listed down in the information memorandum. And I would not rather believe that if the RP does not do the job and leaves it to the valuer, and the valuer does not do that job correctly, then that the whole impact of those encumbrances being there and the actual value of those encumbrances will perhaps hurt the resolution plan or a possible liquidation also. So therefore, I would strongly recommend that these encumbrances are looked into by the RP. The RP has much more powers to ask for information. The whole CRP regulations are filled with how the RP has the powers to ask anyone who is a stakeholder, who is somebody about all these things. the registered valuer, if he writes a mail to a bank or to RICO, I don't think that RICO is required under law to respond to a registered valuer. But an RP's question, an RP's letter legally has much more force with respect to the requirement for the other party to reply to it. And with respect to I think the last part that you talked about, code of conduct for home buyers, I believe the code of conduct is very, very difficult because you have so many people. It is difficult to build a consensus. Uh, what I have seen being done at AAA Insolvency is that you engage with home buyers directly. You build trust with them that this is the best solution for the problem that they're not able to get their home. And if you make the 1-point agenda and sell this agenda to them that through this process we will give you your home, and give you your home in whatever years it takes to build it and complete it. We normally find a lot of consensus there, and the idea is to keep having a practical discussion on what decisions are required to reach at that goal of giving them their home. That has somehow some places worked, some places not worked, but I believe that is the only solution to bring consensus between different varying minds and varying objectives between the home buyers.
Thank you, Ankit. Sahil, there was one question. Can the banks take up services of the insolvency professional to represent them in COC? The answer is yes, they can take, but I have not come across many instances or even a single instance where banks have hired RPs or IPs to represent them in COC. That practically I have not seen. Especially the government banks, they tend to lessen their costs, and whenever they will employ any resolution professional, it adds to their costs. That remains a challenge in any CRP. Yes, it can be done and it should be done because the bank's internal teams are not that much ripe to understand and get a due results in the CRP process. It should be done, but I haven't really seen much things happening on this front.
Sure. Thank you so much, Deepak ji. And without much ado, I would like to hand over to Ritesh Kavadia ji. He has actually been unwell and very kind enough to still make it with us today for this, and he has a subsequent meeting as well. So Ritesh ji, over to you for your address, special address, which we've been waiting to hear you from the horse's mouth directly from the regulator, sir. Ritesh ji, over to you for your thoughts on this e-summit, please.
Thank you, Sahil ji. Very good afternoon to all of you, all the panelists, Mr. Gauri Panda, Mr. Kiran, Mr. Ankur, Ms. Jyoti, Mr. Deepak, and all those who have made it to this webinar. On this valuation system, I must say that it's in a crucial transition phase. I would be wrong if I say that this profession did not exist, but it existed much earlier. The need for valuation was there. Even in the 1950s or 60s, there were SROs trying to self-regulate the profession. But I would say that this profession was just like a cloud, no nuclei, no boundaries. Anyone can say I am a valuer. There is no central command. No one can say this is the voice of the valuers. And this profession paid the price for it. Did not get its due recognition during this phase. There were many who would self-claim that they are valuers, and they would put bad name to the profession. The Company Act 2013 put this. There were many talks earlier, but this Company Act 2013 was the first place where this, at least for the Company Act purposes, a provision was created that there will be a registered valuer. But even this was not implemented unless this requirement of this came in insolvency. Under insolvency, this is very important. Many of you have already elaborated. I would just like to add that under the CRP, there are many aspects that relate to valuations. First is it can lead to wrong decision. If you put a higher liquidation value, stakeholders may be tempted to get this liquidation. Second, it's determines the valuation conducted by the valuers determine the receivable by many stakeholders, dissenting financial creditors, operational creditors, even workmen. These receivables are decided by the value that they determine. So ultimately, and under a CRP, normally the stakeholders are under distress. They are not happy about company being under insolvency. So at least they should have some trust that, oh, look, whatever was due to me under the law, I have got that. If true professional, independent professional has assessed the value, only this much was available on the plate. I have not been shorted by the COC or by the system. So so we for our purpose we required this mm, profession who could determine the value, whose value should be trusted by the stakeholders, and the system can trust upon them. So we requested MC, and MC was kind enough to notify the valuers rule with IBBI as the authority. We understand that this is an interim arrangement. We took it upon ourselves. As I told that there was no nucleus, no boundary. Once IBBI was made the authority for the limited purpose of Company Act and insolvency, at least IBBI got a voice to represent on behalf of valuers, but that boundaries had to be defined. And for that, we chose a system which I believe most of the valuer professionals would have hated, that was conducting an examination. If I say someone to appear for an examination that for the same job that he was doing earlier also, I'm sure nobody would love that. But much appreciation for the community that they have accepted this change, taken things in their stride, moved ahead. Today we have a rich tribe of 4,000, more than 4,000 valuers. Their significance is felt everywhere. Recent some issues like pointed out, like Videocon and all, have highlighted that how much significant their job is. Under developed insolvency process or jurisdictions, most of the cases or challenges come on valuation only, because uh, as I told, many of the stakeholders' rights get determined by the valuers. So this cases or challenges to valuations are bound to come. Professionals have to continuously upskill themselves. They should be ready to justify their professional opinion, how they arrived at it. Or a valuation exercise to be standard and trustworthy, there has to be professionals who do ethical conduct, and they are competent. Apart from it, there should be standard valuation standards. They must all follow unified standards. So work on both the aspects has been on. This committee of experts had recommended a separate institute of valuers for professionals, and another committee have recommended separate valuation standards that can be followed for India. Government is working on them, but as I told, this valuation professionals have to compete with the others who are not registered valuer or doing valuation for other purposes, and they have to continuously compete with the technology, because the more their current portfolio will be taken over by this technology, they have to continuously upskill and move up the value chain so that they remain relevant. And they must continuously try that the stakeholders find value in their valuation. From it, some talks were there on opportunities in distressed assets. That is well deliberated, but I must only say that IBC is a market mechanism, and there must be market should have a perfect good ground to work. Unless the invisible hand of market function well, you cannot expect good results from insolvency. And for a good market, there has to be large number of buyers, large number of sellers, perfect information among them, and low cost of transaction. So among them, information symmetry and low cost of transaction is the responsibility of the professionals, the valuers, the RPs to ensure and to bring a large number of participants, resolution applicants on the table, so that all this talks about leakage of value and all, they are put to rest. Suppose in Videocon there were have been 10, 12 serious resolution applicants, then this base value or liquidation value would not have mattered. It would have been a market. Whatever value you put, if someone is willing to give higher value, that becomes a value. So liquidation value is a distress value, and it does not take upon the enterprise value in stride. So we are on system level, we are working to increase the pool of resolution applicants. Many incentives government has given. We are undertaking continuous advocacy efforts with even globally, and but I would like that the COC, because of their network, they should take on this advocacy effort. Every resolution plan should be marketed in the same way that potential investor does for an FPO or IPO. That should be the spirit, because for resolution applicants it can be okay, missed opportunity, he can wait for another opportunity. For this particular CD it cannot be. For this particular CD it's like Zindagi na milegi dobara. If someone has to something has to be done, it is to be done right now. So COC and RP both have to do some marketing exercise, do some advocacy. They know the industry, they should approach potential investors, do all the marketing effort. On our part, we have empaneled to platform for distress invitation of resolution plan will be a part of their scope of work among the services they will offer. And soon we will see platform for sorry. So soon we will have this. Sorry. Hello. So soon we will have services offered by them. This role and some responsibilities of COC, I think much has been said. Nothing much to add. Only thing is that's apart from this empowerment, there are many issues that are coming up. Many times AA has commented adversely on the working of AA. Many stakeholders, including this parliamentary committee, have felt that there is a need for having some code of conduct. But that remains under consideration. So I would not like to add much on that. So that's all from me. Thank you very much for inviting me, and all this panelists have provided very, very important practical aspects. We look forward to hear from all of you what kind of challenges they are facing, and we try on our level best to resolve them. Thank you.
Thank you so very much, Ritesh ji, to give your very valuable insights despite your ill health. Still make it with us today and give your insights as a regulator, being at the forefront of the entire ecosystem. It has been a great interaction today, and I would like to take the liberty to ask one question which has been asked at the panelist, and since it is not a specific name, but I will leave it to the panelists to opt to answer this question. So liquidator, the question is, the liquidator has filed a PUFE transaction, preferential undervalued fraudulent extraordinary transaction, with NCLT during the liquidation tenure. However, liquidator is able to sell the CD in liquidation process within 6 months from the LCD, and decision on PUFE transaction is still pending with NCLT. Now, who will be responsible for taking care of this transaction with NCLT? Is it the liquidator or the lead lender? Usually the lead lender are very reluctant to do the same. With your vast experience, if you can suggest, how can we move forward in this situation? It's a practical question and a situation asked, and I would like to open it to the panel.
If other my co-panelists who are lawyers want to pick this, they can. Otherwise, then I will pick this. In fact, this question and the next one is linked. So
Yes.
Mahima, you want to, or Ankur, you want to take, and then I'll pitch in, because there has to be one common answer, which I have, but let others answer.
So let's see. I think I'll take the second one first, because honestly, on the first one, it's a gray area. There's nothing in the regulations. It doesn't provide anything on what happens to avoidance transactions, PUFE transactions filed in liquidation. Similarly, for a CIRP scenario also. But in Venus Recruiters, the Honorable Delhi High Court has held that once the CD is resolved, once a plan has been approved, the resolution professional cannot wear the hat of a former RP and pursue the avoidance application. However, there's a caveat. The Venus Recruiters judgment also says unless a specific provision is made in the resolution plan. So my reading of the Venus Recruiters judgment would be that if there is a specific provision in the resolution plan as to what would happen to the avoidance proceedings after the plan is approved by the NCLT, and how would the proceeds of the avoidance be distributed, unless a specific provision is made in the plan itself, at least keeping Venus Recruiters in mind, it is not possible for an insolvency professional to prosecute these applications, and it is not, in fact, the Delhi High Court has held that NCLT does not have jurisdiction to adjudicate such applications. So we have this, of course, Venus Recruiters is in a CIRP scenario. Probably the same logic would apply to a liquidation scenario as well. But there I'd just hand it over to Jyoti to add her.
I just add in, I think that judgment has already under challenge
Yes.
by the banks, and still no decision has been taken in that. And normally, if you see the resolution plans, they generally provide that whatever the recovery happens through the PFUTP transactions, it normally will go to the financial creditors. So in that way, even if the RP is as per the Delhi High Court judgment, even if it is not the authority, then obviously the lenders they can pursue it either through their persons or through their RP. They can authorize him to pursue the things. So again, this is a very gray area. And if you see in general, whatever the Section 43 and other transactions which have been filed with the NCLT, I think very rare certain judgments orders have come in those cases, because things are going on. That is always in the doesn't take the precedence if the hearings also happened, and in some where the orders have come, they are certainly under the challenge. So that is again a very gray area, but normally the resolution provide. And as far as the liquidation is concerned, as a liquidator has a different capacity unlike the resolution professional. If you go to the good old days where the liquidator appointed by the High Court, they can pursue all the legal cases, and whatever the recovery happen, those recoveries are at the point of time subject to the liquidation pool and distributed to the different claim holders. So I think for the liquidation, it is the liquidator who can pursue the claim even once the company is under the wound up or whatever the situation. He can continue with all these transactions. This I think Jyoti can put more insight on that.
Yeah, so I'll just conclude it. So basically, according to me, see, when any avoidance transaction is filed, there are three things that can happen. If it is filed during the CIRP and the company is going into liquidation, then it will transition to the liquidator. Liquidator will deal with it. But in both the situations, whether a resolution is happening or a liquidation is happening, according to me, it will have an untimely death. You know, these applications, at least before the NCLT, for a very simple reason. A resolution plan is a creation of the resolution applicant. when it is not really quoting the value based on what money will come back, then surely it is not going to muddle up the resolution plan, including something that can happen in future. RP is a functus officio. The all the lenders, as far as the resolution under IBC is concerned, are in a sense come to an end. While how they separately deal with proceedings which are either criminal in nature or which are against the personal guarantors, which are against the corporate guarantors. In the same way, they have to, outside of the IBC, outside of the NCLT, they need to continue with that in case, but that will not be a COC, that will be a lenders forum or something separately who needs to then take that action. According to me, the only practical solution of this will be, and which is in a way again has been done by IBBI, is that now the RPs have been held accountable to say that you file a form, okay, which came, the circular came on 20th of July. They are saying you need to have your own opinion, okay, and that opinion you need to submit on the, you need to form an opinion on 75th day. And then by 135th day, you need to file an application. So with a tenure of 330 days CIRP, if you file an application on 135th day, according to me, a resolution will happen before the resolution plan approval. And practically what I have seen is in one of the matters that I'm dealing with, they are finding shelter behind the, who are these, what do you call, forensic auditors. So when they come on the forensic report, then they say, oh yeah, now one transaction has come, and they will just put the forensic report and they'll file it. In my matter, which I'm dealing with, there are 4 applications filed because every application ends with a line, there is still investigation happening, there is still forensic audit happening. So there has to be an end date, and with this action that IBBI has taken, where they need to take a decision on the 75th day, I feel that if it is done timely, it will, sort of be resolved timely. So that is the only way. Otherwise, as Ankush said, that it has to be exercised outside of IBC. NCLT can't be sitting here to ensure that the lenders keep getting more money just because, these have taken time. So this is my view. Thank you.
Thank you so much.
Thanks, Jyoti. Just to add one, I'll just leave one more thought here. And again, it's coming from practical.
Be quick since we overshot time.
I'll just take a minute, but just to add to this point, what we are experiencing in a number of NCLT benches is that, especially in light of Venus recruiters and the timelines which are specified in the regulations, a lot of benches have started insisting on the avoidance applications to be heard before the plan approval application. So that is another thought that we should bear in mind.
Great. So thank you so much to all panelists, special address by Ritesh ji, and to all the participants to this webinar. And on behalf of ASSOCHAM's National Council of Insolvency and Bankruptcy and Valuation, I thank one and all to attend this. It was an interactive session. We still have a few Q&A, but because of the lack of time, we are not able to address them. But what at ASSOCHAM we will be doing is that we will be giving in our representations to the ministry and other regulators regarding the findings and the discussions which have happened and transpired. And I also like to thank the entire team at ASSOCHAM to put up a great show, Rajesh ji, Vivek, Mayank, and I would like to hand over now to Dr. Rajesh Singh for his vote of thanks. And Rajesh ji is the Deputy Director and Head at the Department of Banking and Financial Services at ASSOCHAM. Over to you, Rajesh ji, for your vote of thanks, please.
Thank you so much, sir. And first of all of you. On behalf of ASSOCHAM, I would personally express my sincere thanks to Ritesh sir. I know, sir, today you have a very hectic schedule. You are not well. In spite of all these challenges, you have consented our request and addressed the special address here. So thank you much, sir, for your valuable time. Also, I would like to thank our eminent panelists for sparing the valuable time. And today's discussion is very easy. I have learned each and every aspect today, and I am very delighted today. So thank you so much for all the panelists, valuable time. And lastly, I would like to thank our delegate who have joined today for this timely and meaningful discussion. And last, I look forward to welcome all of you in our last edition, and definitely that edition we will make some more effort, and we will And this effort will be making the more interesting to the whole system. So thank you so much. Very soon we are going to announce that our last edition. So just allow me 1 and 2 analyzing the each and every aspect and
Okay.
Thank you so much. Thank you so much.
Thank you, Ritesh ji. Thank you, Sahil. Thank you, everyone.
Thank you, everybody.
Thank you, everyone. Thank you, all the delegates.
Sahil,
Thank you, all the panelists. It was a pleasure interacting with all of you. Thank you.
Thank you.
Thank you all of you. Please take care.